Hello there, my name is Luciano Oliveira. I am a Brazilian attorney, also licensed in California and Texas. And today I'm going to try to answer this question. Disputes in Brazil, should I negotiate or sue? The answer is that maybe a combination of both, but we're going to address here some topics that may help you understand the dynamics of a lawsuit in Brazil. One of the factors for you to consider is like the distance factor. The distance factor means that whenever you are dealing with a Brazilian party, particularly if you are far away, like if you are in the United States, if you are in Europe, if you are in Asia, the Brazilian party thinks about you as someone, whether an individual or a company, that is too far away to hurt or to take a decisive action against this Brazilian party, right? So what we see is that, let's say if you have a vendor in Brazil, if you're buying either a product or a service, and this vendor in Brazil, like they have some kind of difficulty, one of the easiest things for this vendor to do is to kind of cut you loose, right? Let's say if they are unable to deliver what they are selling to all their buyers, they are usually gonna prefer, to kind of default with the external, with the client abroad, because again, the distance factor, particularly in our culture, like in Brazil, we just think about, people talking, speaking a different language, locating in a different continent. It just sounds like, too far away, too removed from our everyday reality. So once you understand this factor, you're also gonna understand that whenever you retain Brazilian attorney or law firm, this attorney or law firm is gonna have a better approach to get this vendor or this party to perform what they promised, what they should have done. Because again, the Brazilian party, once the Brazilian party sees a Brazilian attorney located in Brazil, naturally they say, all right, now this is like closer to me, this is closer to my reality. It is someone speaking in Portuguese, licensed in Brazil. So the chances of getting performance from this Brazilian party is gonna increase substantially. Another tip we have here at the firm is like to combine actually, like a settlement attempt with litigation. And the idea behind this approach is because whenever you're trying to settle, whenever you're trying to negotiate outside of the scope of a lawsuit, first, the non-performing party, we could be, a debtor or someone that is not fulfilling their role in a partnership. It's much easier for them to just kind of postpone or to offer a kind of lowball type of proposal. Now, if they feel the pressure, if you file a lawsuit, this is going to create a maximum pressure, because then this party knows that, like once the claim is in the legal system, chances are if they don't settle for something, like they may be ordered to pay not only like the full amount of the lack of performance, but they would also need to pay attorney fees, which can be up to 20% of the value of the claim, in addition to interest, in addition even claim like, damages because of the lack of performance. So whenever there is an actual lawsuit, your leverage to negotiate and settle increases exponentially. Finally, there are some very objective advantages of settling after filing a lawsuit. So what we're talking over here is that instead of settling before a lawsuit, first you file a lawsuit and then you move to secure a settlement. And the advantage here, the main one in my opinion, is that you don't need to wait for the life cycle of a lawsuit in Brazil. Unfortunately, in Brazil, it's not uncommon for lawsuits to last over 5 years, sometimes over 7 years. So nobody wants to, wait for all of that time. And that means that once you file the lawsuit, again, you give maximum pressure on this non-performing party in Brazil. And then, at the same time, you say, well, if you want a way out, let's talk about fair terms for a settlement. So, the timeline, I think, is the number one advantage. But there are other advantages, in particular the service. Like serving a party in Brazil is not as easy as it is in the United States. In the United States, you can use private parties to serve the process on the defendant, right? Like you get anyone, like you don't need any special type of education, any type of certification. It could be pretty much anyone, aside of a few exceptions defined by the court. But again, the point here is that in the United States, you hire private parties to serve the process. In Brazil, that's not the case. In Brazil, we use the so-called oficial de justiça, or, trying to get you a rough translation, it would be, like the justice system officer to serve the papers on the defendant. And therefore, there is a limited number of process servers in the country. And not only that, you kind of need to get into a queue. And because these people, they are not really private parties, guess what? They are more like, state actors, if you will. Like they are going to perform as state employees, right? So not super motivated to get like the service done. They're more on a schedule. They have, their kind of work guaranteed. So not as competitive and aggressive in terms of getting someone served as you would see in the United States. And we had the cases here at the firm in the past in which we could not serve, like the defendant, because the defendant naturally was hiding. Even if he is like, a businessman, if they are running a company, there are, games to play in Brazil, as you may imagine. And in such cases, like it was possible for us to actually file the lawsuit and then, try to serve the defendant. The defendant is hiding, and some way we open a communication channel with the defendant. And guess what? We get a settlement negotiated in the meantime. And once we have the agreement from the client, what we would do is to actually file the negotiated settlement in the scope of the lawsuit, because in this case, the lawsuit itself would confirm the service. And let's say if the Brazilian party in default would not perform the terms of the settlement itself within the scope of the lawsuit would allow the court to, go after the defendant without a need to serve the defendant with the process. Okay, so this is another major advantage, getting a settlement post-filing the lawsuit. And another advantage is that maybe you can cure defective lawsuit paperwork. And let me give you an example. Very common in international trade, right? Like to have, for instance, a distributor in the United States. The distributor in the United States buys from Brazil. And guess what? Like whatever paperwork this player in the US, this buyer in the US is using, is going to be based on the US legal system, right? So very common for whatever paper is being used in those transactions to be not fully enforceable in Brazil. Another very common case we see, if the Brazilian party is buying a product from a supplier in the United States, and if you're in the default, like sometimes they try to negotiate directly, like the US seller with the Brazilian buyer, and the Brazilian buyer company says, like I am in a peak over here, but I'm gonna get things back on track. And by the way, just to make you confident about my situation, I'm gonna sign a confession of debt, right? And not surprisingly, the Brazilian party is going to provide a document that is not fully compliant with the Brazilian law. For instance, the Brazilian Civil Code says that for a confession of debt, the Brazilian party should have like witnesses on the instrument in which this Brazilian party is confessing the debt. And again, not surprisingly, the debtor is going to do what? They are not going to add the witnesses. So you get this paper, you're very happy, and then down the road, again, not surprisingly, the Brazilian party does not perform even after, confessing the debt, maybe trying to get further credit lines. And then when you go back to the Brazilian court and you file a lawsuit, guess what? The judge is going to look at this document. The judge is going to say, well, this thing is not compliant, and therefore I'm not going to accept, this instrument of confession of that. And then you could be doomed, right? So what we do is we file the lawsuit, and in parallel, we try to get a settlement with the debtor, because if we get a settlement, the settlement would cure the underlying paperwork, because, from the judge's perspective, if the parties, if they want to enter into an agreement within the scope of the lawsuit, the judge is going to be more than happy, to give the judge's blessing on the settlement agreement. And it's going to be one last case on the judge's desk. And again, once this has the blessing of the judge, whatever underlying defective paperwork was there is not going to be relevant anymore, because then there is going to be a settlement agreement in place. All right, so these are just some of the aspects that you could consider when thinking about negotiation and lawsuit in Brazil. Many times the best strategy to negotiate is actually to file a lawsuit. And if you have questions about your case, feel free to schedule a consultation with our firm. We're going to review your case in a Zoom call. We can answer questions and get you up to speed in terms of the options you have in our market. Don't forget to download our ebook, The 7 Things You Must Know When Pursuing a Claim in Brazil, and follow us for more tips.